Your leadership as since you're talking about like the national sovereignty and integrity that's given down in Article 2, Part 7 of the United Nations Charter, I think we are aware. It also mentions at the end that as long as it does not fall under Chapter 7 of the United Nations Charter, whereas the respondents of government, the Andalusian government, went to the United Nations with an appeal, went to the United Nations Security Council with an appeal, and this basically falls under the Chapter 7, and hence the national sovereignty that's very much falls. Hence, if they fall, if they fall, and also the conventions and the idea that for privacy, as long as it does not fall under the Chapter 7 information of that particular country, like whereas as Article 7 says that the responsibility of the government and government from that United Nations has went to the United Nations to that area, and this basically is after that convention is very much issue of that exists, which is not the important one, as the context is the conventions and the idea that for privacy, as long as it falls under the Chapter 7 information of that particular country, like whereas as Article 7 says that the responsibility of the government and government went from that Article 66 of the International Court of Justice. His name is and he is the head of the National Liberation Group.
Permitted.
Thank you, Honorable Bench. He's supposed to say. So, so there are three questions that I basically want to ask. First one, was energy, what is the main cause of the formation of energy?
The main cause of the formation of the energy was literally that the people the people that were refugees from Endor wanted to create a safe organization that created that national liberation group, that created in the form of national liberation group.
So, what was the impact of calling energy a terrorist organization by the government of India?
I am the then founding head of the energy group, and I feel very unsafe in this country in Anvil because my companions are literally calling me terrorist, and I cannot share my personal data and I cannot call my family because my data is accessed by the government of Anvil, and I am literally being discriminated. Not only being discriminated, but also my right to privacy is being deteriorated here. And my father has died. I cannot communicate to them because they are offering charges. They are seeking my right to privacy, and this is very wrong because according to the Article 21 of the Constitution, it states that I have the right to privacy.
The arguments have that is acknowledged. Now, this one last question. Does energy by any means has any association, or does energy got any chance to prove it to have a fair trial in the Andean government's court before it was acclaimed as a terrorist organization?
Can you repeat your question?
Was energy given any chance to a fair and public hearing in the Andean government?
The clear answer is no.
The Honorable Bench, I hope that is acknowledged, which in itself is a violation of certain articles that I stated. Other than that, I would now like to move to the issue 3 of our document that states, is the social credit system violating the right to privacy of the refugees and the intellectual property rights of social media platforms? The honorable bench. It is humbly committed to the honorable court of justice that the demand for provision of personal data of an individual is a strict violation of right to privacy and of an individual by Article 17 of the International Covenant on Civil and Political Rights and Social Rights. System violating the right to privacy of the refugees and intellectual property rights. The Organization of the International have discussed the honorable bench earlier. It is humbly committed and honorable court takes that the amount of damages or and Consumer Act of 2021 was deliberated upon and was brought in order. That law stated, this bill requires online platform operators to inform a user prior to a user creating an account or otherwise using the platform that the user's personal data produced during online behavior will be collected and by the operator and third parties, taking their consent. The important point is that. But without taking their consent, it is considered illegal in North Australian States of America, but there are multiple right to privacy laws prevailing throughout the world. Other than that, for the intellectual property rights, further violating the World Convention of 1971, Article 6, referring to WTO Agreement on Trade-related aspects of intellectual property rights, Article 10, Part 1, such that which clearly states that the source code of a particular organization of a particular application shall be considered under the as a literary work under the World Convention. In such a case, there are several violations as it has already been stated, and hence did not provide any sort of information about utilizing that.
Yeah, arguments and please continue.
You have completed your arguments. Your colleague will go first.
Greetings to the Honourable Bench. With the due permission of your Ladyship and your Lordship, would they like to be referred to as the Honourable Bench?
Please.
Thank you, Honourable Bench. Your Honourable Bench, as the court has already knows the statement of facts, as my counsel has already told the court about various facts which prove our point. Now, with your due permission, Your Honourable Bench, the co-counsel would now like to proceed upon issue 2 and 4, which is mentioned. Is the Social Media Regulation Act and Official Notification 21/2019 a viable solution? Your Honourable Bench, it is humbly contended to the Honourable International Court of Justice that the localization of data by Social Media Regulation Act, that there is a direct violation of Article 6 of the GATS Part 1 due to notification number 21/2019, which provided land to build data centers in the eastern part of Andaman, which had cold climate. Your Honourable Bench, Article 6 of the GATS states, and I quote, in sectors where specific commitments are undertaken, each member shall ensure that all measures of general application affecting trade and services are administered in a reasonable, objective and impartial manner, unquote. Your Honourable Bench, despite this fact, in this case it is quite evident that the Andaman government made certain policies which were unfair for foreign companies as all the other data centers, foreign social media companies, as in this case, Be Connected. Honourable Bench, the cost of setting up data centers for Be Connected increased substantially high, since they had to import majority of the technological equipment for the data centers from Barantan. Your Ladyship, further they had to invest in high performance cooling systems, which is necessary for the cooling of large data systems which would be set up which would be set in the state of Andhra. Furthermore, Your Lordship, despite these cooling systems, the efficiencies of B Connected's data center was reduced because of the hot weather conditions of the state of Andhra, which is quite evident to the fact that the state of Andhra not only provided unfair grounds for trade, but they also tried their level best to create a market disparity between the their local firms as well as the foreign social media companies. Furthermore, Your Lordship, this significantly impacted the technical performance of Be Connected. Honorable Bench, the website started hanging out often, and the user had to forcibly terminate the program without logging out, which led to some problems for the users and in particular the Indorian refugees. Your Honorable Bench, this led to a decline in user friendliness of the Be Connected interface. Be Connected's buddy search option and internal messaging system also took longer to perform their functions, which, as the court already knows, was critical for each and every Indorian refugee, as the court already knows, that the Indorian refugees were constantly using the Be Connected's social media platform. With that said, Honorable Bench, the declining number of users in Anduin resulted in less revenue generation through the advertisements, which led to Be Connected's revenues getting lower, and they started incurring more and more losses. Now, with the due permission of the Honorable Bench, the co-counsel will now like to move upon to issue number 4, which is mentioned in the arguments advance.
Before that, there is one question for you. That even before we are talking about this change, they have provided you as a country, it's in their right to promote their domestic produce. They have to improve their economy. They are not obligated to provide better facilities to a foreign investment, firstly. Secondly, as a country, even before Be Connect, they were shifted the base of Be Connect. Before that also, Be Connect has lost a lot of usership because of the increasing programs or increasing incentives provided by the trust. The Let's Talk, where they have WhatsApp and other giants where they have collaborated and provided video calling. So Be Connect is not facing loss because of this, but Be Connect was facing loss because of a healthy competition.
With the due permission of your ladyship,
Yes.
Can I answer?
Yeah, please.
Honorable Bench, first of all, we need to understand the difference between a profit and loss. Respectfully. Your Honorable Bench, first of all, Be Connected started incurring losses from the first time when and the state of Andhra imposed this particular Social Media Regulation Act, which not only was unfair for Be Connected, but also the state of Andhra gave Be Connected less favorable ground to proceed further with their activities. Because, Your Honorable Bench, if a particular state of a particular country wants its particular domestic goods or services to be promoted, that's their basic impulse, their basic want. But keeping that in mind, if the state of Anduin has, and let's say will impose the Social Media Regulation Act, it will lead to market disparity between the local firms and the foreign media firms, given the fact that if the state of Andhra does not want to collaborate with the foreign social media firms, then that will lead to the decline of their economy, which any particular president or any particular prime minister of any respective country would avoid. And Madam, your ladyship, with that said, with your due permission, the co-counsel will now like to proceed further upon issue 4 of the arguments advanced.
Please.
The Honorable Bench, issue 4 states that can the Data Localization Act be considered legal pertaining to WTO agreements GATS and GATT? Your Lordship, it is humbly contended to the Honorable International Court of Justice that there is a direct violation of Article 6 of the GATS Part 1 due to not providing impartial trade advantages to social media organizations. Your Ladyship, Your Lordship, Article 6 of the GATS Part 1 states, and I quote, in sectors where specific commitments are undertaken, each member shall ensure that all measures of general application affecting trade and services are administered in a reasonable, objective and quote-unquote impartial manner. With that said, Honourable Bench, by notification 21/2019, the Anguinian government drafted certain policies which were unfair and treated foreign companies unequally than their domestic firms, thus increasing the market disparity between local and foreign services. Your Honourable Bench, under the principle of WTO Trade Without Discrimination Clause 2, which states, and I quote, treating foreigners and locals equally, imported and locally produced goods should be treated equally at least after the foreign goods have entered the market. Your Lordship, the same should apply to foreign and domestic services and to foreign and local trademarks, copyrights and patents. This principle of national treatment, quote unquote, was not given to be connected. Your Lordship and Your Ladyship, keeping that in mind, the Co-Counsel would like to state that if the state of Andaman in the first place didn't want to make friendly relationships or make certain fruitful trade policies with the Be Connected, with the social media company called Be Connected, then they shouldn't have given us the place in their country in the first place, because keeping that in mind, Be Connected, the state of Andaman is not only promoting their domestic goods, but also they are neglecting the goods and the services which is essential for the Andorian refugees. Plus, Be Connected, the company Be Connected is exactly doing that. Be Connected is providing them with social media platforms which the Andorian refugees can use to talk with their friends, to talk with their families, to talk with their parents. Because keeping that in mind, most of the refugees who come from the state of Endor have witnessed a particular state of violence, sheer violence. They have witnessed massacre. And this whole problem goes to General Radal, who is the main culprit of this refugee crisis. And keeping that in mind, Honourable Bench, the Co-Counsel would again like to state that if state of Andaman doesn't give the right, doesn't give favourable playground and favourable policies through which Be Connected can in future could perform better, which would lead to a betterment of the refugees, of the Indian refugees, then the state of Andaman can do one thing. They should either promote their domestic goods, or either they can look after, they could look after the betterment of the Indian refugees, which is the 15% of influx from the state of Endor. With that said, Your Honourable Bench, the Co-Counsel will now like to begin his prayer. With the due permission of the Honourable Bench, the Co-Counsel will now like to proceed further with the prayer.
Please.
Thank you, Your Honourable Bench. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, may this Honourable Court be pleased to declare and hold that, first, to declare NLG as a peaceful association and arbitrator and or interlocutor for the Andorian refugees. Two, to declare that the agreement of Andaman has violated multiple privacy laws by a localization of data, quote-unquote, act. 3. To declare that the social credit plan is a violation of the privacy of refugees and intellectual property rights on the social media platforms in general and Be Connected in particular. 4. To declare the Andaman government guilty of violation of the GATS and GATT by provision of impartial trade benefits. 5th. To declare that the power of judicial review is sacrosanct and cannot be compromised through any legislation. And or pass any other order it may deem fit in the interest of justice, equity and good conscience, all of which is most humbly and respectfully submitted to the Honourable Bench. With that said, we rest our case. Thank you very much.
Thank you.
Representing NLG also.
Okay.
Representing
They haven't.
when they are not,
Why they, and they have not asked for compensation. Yes, next.
Next.
With the due permission of the Honourable Bench, can I please? Thank you. Thank you, Lady.
With the due permission of the Honourable Bench, can I start?
Yes,
Just
please.
give only 1 minute. I want on the way to moving to court. Yeah, हो जाएगा तो 19 नंबर डिवाइस चल रहा है Yes, yes, yes. Sorry for this.
Right.
Yes.
So we are the respondent council and we are representing the nation of Andwin at this court proceeding. So with the statements of facts at the very onset, as the petitioners have already mentioned the statements of facts of the case, we would like to highlight one very important statement in the facts, that the head of the security intelligence unit of Andwin said that all the people involved in the terrorist attack that happened they were related to NLG and planned the attack through Be-Connected's internal messaging system. With that, I would like to elaborate on the structure as to what the side respondent would be following. I would be firstly elaborating on the working of the international law and its implications in the domestic law. And my co-counsel would be bringing up arguments, detailed arguments with backing up of the international conventions and law. So at the very onset, we need to understand that national sovereignty and right to national integrity and security is a non-compromisable principle. It is granted by the United Nations Charter that a nation may do something in order to protect its national sovereignty, its national integrity. And in this case, we need to understand that Andwin follows dualism. In the components of international law, are the various functions that it brings out. The treaties, the conventions, the protocols, and the customary law of international practice, the peremptory norm of national practice. We need to understand that till the time these international instruments are codified and are actually implemented in the domestic jurisdiction, they only have a persuasive authority over a nation. They don't have any binding authority. In this case, the UDHR, the Universal Declaration of Human Rights, has a persuasive authority on Andwin, but it does not have a binding authority. But the municipal law of our nation may take inspiration from it, and we will do everything in accordance with the international humanitarian law. However, we need to take certain action in order to protect our national sovereignty and national security, which was actually threatened in this scenario. Moving ahead, we need to understand that NLG is a group. They are representatives of the refugees who have come from Endor to Andwin. And Andwin has taken every effort in order to ensure that these refugees get their basic rights. Only the right to transit has been violated, and that is again done to protect the national sovereignty. Moving ahead, it was found with the help of the officials of Be-Connected that certain officials, that the members who planned this attack, even though we had on-ground mechanisms to prevent this terrorist attacks, like the border patrolling unit that was present on ground for the identification of these refugees, this attack still got conducted. And this was due to the messaging system, the messaging platform of Be-Connected. And they conducted this operation through many places that actually led to public disorder. Moving ahead, secondly, we need to understand that non-refoulement. The petitioners stated that we have denied the entry of many refugees that led to the massacre by general return. It was stated that. We need to understand that non-refoulement is again a principle. That is mentioned under the UDHR as well as the United Nations Convention on Status of Refugees 1951 and the Protocol of the year 1967. However, Andwin is not a signatory to this convention. Therefore, we are not bound to follow it. We are doing everything in accordance with our internal policies. And for this case law, we want to present to the Honorable Bench Mohammad Salimullah versus Union of India case on 8th April 2021. Please we advise the Honorable Bench to read clause 10 of the very judgment. Moving ahead to data localization. Data localization briefly states that the data that has been produced in our nation will remain within the borders of our nation. And this is again done to prevent public disorder, to prevent public disruptions. NLG has been making videos, sharing false videos with the conduct of Andwin on social media. And what we have asked Reconnected, that they have denied to do so, is to provide us the data. We will not for the infringement of privacy, rather to block such ads, such videos, so that it does not spread false information and false news about anything.
Okay, don't you think that a government asking personal data of its citizen is violation of their privacy? Of not even citizens, of anyone, and BConnect is within their rights because they have an agreement with the users that without their consent they are not going to share their data. So why should you actually force a particular organization, entity to share the data with you? And again, when you say that, when you talk about international laws specifically, aren't you bound by the international trade principles?
Yes, ma'am. So, may I answer that?
Yeah, please.
So, at the very outset of my answer, I would like again highlight we have not forced BConnected to share the data with us. We have only asked this because we need to understand that no right is absolute. No right is absolute. It is flexible in certain circumstances that can be deemed within the nation by their internal policies, and till the time we are not bound by an international obligation that has been codified into our municipal law, that has been followed by a domestic law, we are not obliged to follow that rights. However, it is briefly mentioned, it is clearly evident that in the previous meeting that we had, many nations recommended us to start allocating more funds towards the betterment of these refugees into the demarcated zones for better supplies, which we have been doing so. We have been giving them the basic human rights in accordance with our internal policies. Moving ahead with the terrain differentiation and the 5% electricity bill that was bill reduction that was proposed. BConnected was given a choice. BConnected was given a choice to use the equipments of our very nation. That was a choice that was given both to Let's Talk and BConnected. Treated fairly, both have been given the same option. BConnected chose to use the equipments that were from Barrenduin, and Let's Talk chose to use the equipments that was from our nation. Therefore, leading to the revenue generation of our nation. Therefore, 5% reduction was in that case very justifiable and equal in this case, because if this was an opportunity again presented by the government. Opportunities can be presented to both the nation, to both the companies. If it was only given to Desktop, then it would have been called discrimination. However, it was given to BConnected as well, and on its own accord, it chose not to select that. And moving on to the terrain differentiation. Allocating lands is a very private matter of a nation. Allocating which land to which company is a very private, and we believe that it is highly undiplomatic to ask the nation why they have done so, because this is basically intervening in violation, which actually violates Chapter 1, Article 2, Part 7 of the United Nations, that you cannot intervene a nation to tell you anything. That actually violates the nation's national sovereignty. And again, we justify that everything is done to prevent public disorder, to protect our national sovereignty, and we believe that the side petitioners who are from Barrington also believe to uphold national security and national sovereignty, and they believe that
Do you think in the name of national security you can trample basic fundamental rights of people, of individuals, of companies?
Ma'am, with all due honor, may I answer? Ma'am, no rights have been trampled in this case. No rights. The Social Media Regulation Act that was given so that these refugees may get refugee status in our nation, may get to live in our nation, was done to enhance our security. It is giving the mood problem that border patrolling guard was already present there, because when a refugee enters the state, it goes, before attaining any status, it goes to an identification process as to whether that refugee poses a threat to that nation or not. In this case, the border patrolling unit actually conducted their duty. However, it was neglected, it was missed by any unprecedented action that missed, and that led to these terrorist attacks. Therefore, combining with social media to actually regulate, because as the side petitioner stated that NLG has electronic devices. NLG has electronic devices to upload videos. They have digital technology. Therefore, using the platform which they work on with the consensus of Be Connected. This is not forced. We have asked them. Data localization is another thing. That means that storing the data within the nation. We have asked Be Connected to actually help us in enhancing our security so that this terrorist attack may not appear. And moving ahead with deeming NLG as a terrorist organization is viable or not. In accordance with our intelligence, NLG is related to this terrorist attack, has been a very major part of this terrorist attack. We need to understand that there is no codified definition of modern day terrorism. Yes, there is no codified definition of modern day terrorism. We cannot code something. We cannot differentiate between a person who has radical thoughts and between those who actually plan on committing it. And in this case, it has been found by our defense, by our national intelligence unit that they were related. Therefore, they have actually committed acts of aggression, and they were not affiliated with the nation. Therefore, they can be deemed as acts of aggression of violent non-state actors. And this is what was requested in the United Nations to deem them as international terrorist organization, international violent non-state actors, so that they may not pose a threat to the international peace and security at the most. With this, I would again like to, for the data localization part, I would like to give it, for the data localization part, we need to understand that even if we take the case of COVID-19, that was in India, there were, in the world, there were a lot of false information that was being spread via social media. Via social media, information was being spread, false information, and therefore the government actually requested the assistance of that social media platform to actually stop the spread of this information, to actually prevent public disorder, to uphold public dignity.
There is a difference. You want to stop something, dissemination of fake information, of wrong information, and asking for data or asking for storing everything in your country are two separate things. Be Connect never said that they are not going to stop spreading false information. They said they're not going to share, and it does look that when they refuse to do that, you try to discriminate them by giving them lesser ground, or what you say, as when you say that you try to push them, create differences between the two. Let's talk and Be Connect. Isn't that true?
No, ma'am.
Okay.
Bench, I would like to tell them they have their last 50 seconds.
Okay.
Ma'am, we deny this fact. What we actually wanted and want is the assistance of Be Connected. Data localization, Be Connected has been operating in our nation since 2015. Since 2015, Be Connected has been operating, and they have not complained about anything. And in this scenario, it is the question of national security and national integrity, and we have only requested them. It is not forced because both of them were given the same option, same opportunity, and both of them chose differently, therefore they got differently. They got differently, and this was nothing related to discriminating between a foreign company as well as a native company. Moving ahead, lastly, I would like to
With
again
the permission of the honorable bench, I would like to tell them that their time is over.
10
We can
seconds.
give. We can give the time.
Give.
We have other question.
Yeah, so I would like to sum up, I would like to just state my last point, is that data localization, what we propose in data localization is that for the time being, till the time we have emerged, we have gotten out of this crisis situation. We have gotten out of this crisis situation. We believe that storing the data within the borders of our nation would actually prevent any leakage of any data and leakage of any data outside our nation, which we don't want. And that is again a question of our national sovereignty. Now my co will be taking up.
There are two questions. है टाइम पूछ सकते हैं ना? इनकी स्टॉप वॉच उतनी देर के लिए, लेकिन उनका टाइम अभी शुरू मत करना, मैं इनसे क्वेश्चंस करूँ, ठीक? यू हैव सेड, आपने कहा कि जब भी कोई रेफ्यूजी हमारे यहाँ आता है तो हम उसका सिक्योरिटी चेक करते हैं प्रॉपरली, ठीक है? एंड इट इज़ योर एडमिटेड केस, यू हैव आर्ग्यूड दैट due to some reason it was the fault of your security officers, ठीक? What action you have taken against them? First thing, your total argument is कि अगर इन्होंने डेटा दे दिया तो हमारे यहाँ नेशनल सिक्योरिटी का इशू रह ही नहीं जाएगा. Is it your case?
So my case is basically to combine with social media to enhance, not if they give, there may be a chance that the issue might not resolve. However, there is a very big chance that the issue may resolve if we combine with the social media. And secondly, the nation has approved for an investigation unit to be present to investigate the loopholes in our working system as to why this terrorist attack could have happened. And we have got this information that this was done through be connected.
टेररिस्ट अटैक इसलिए हुआ कि कहते हैं कि इनके यहाँ लोग जुड़ करके कैंपेन चला रहे हैं, या टेररिस्ट अटैक इसलिए हुआ कि आपके रिफ्यूजीज को आपको जो सुविधाएं देनी थी वो आप नहीं दे पाए, या आप इतने ही श्योर क्यों हैं कि रिफ्यूजीज के थ्रू ही ये काम किया गया है? क्योंकि आप ही के मूड में है कि आपके भी 8 सिटीजन्स ऐसे हैं जो इसके साथ इन्वॉल्व हैं. तो देयर इज अ फेलियर ऑफ द स्टेट कि वो उन लोगों को ये शायद कन्विंस नहीं कर पा रहे हैं कि हम आपको अपने देश का अलग हिस्सा नहीं मान रहे.
So sir, basically for this loophole, why this terrorist attack actually happened. So for a terrorist attack to happen, they need a lot of planning with resources. They could have occupied resources from anywhere. So even from abandoned factories, they can build up a weapon or anything that they may use to harm something. Stopping resources, tangible resources, is very, and intangible as well, is very difficult for every nation. If this could have been possible, the problem of terrorism would have resolved till now. However, it hasn't, because it is very tough to identify between the people. In our nation, the border patrol unit that was present there has tried their best, and due to certain unprecedented options that may have happened in any nation that has actually suffered with a terrorist attack. Because it is stated that it is our first terrorist attack. This is our first loophole. Before this, we didn't have any terrorist attack. And it is also stated that yes, our citizens have been a form of this terrorist attack, and certain refugees have also been a form of the terrorist attack. We agree to that. If if these citizens are actually found to be guilty with evidence, with a valid pretense, they will be dealt with under our domestic municipal law. However, for these refugees, you need to understand, firstly, we need to identify among them, because there 15% of Andorians have been coming to Andaman, and we have not done anything that would actually, in very informal sense, upset them, because it is clearly mentioned. It is clearly mentioned that we have been providing them resources, we have been using our funds, using our financial assets in order to give them those necessities, give them those resources. Now my forward statement.
Commissioner for Honorable Guest.
Please continue.
As a second speaker, I would provide some issues and further elucidate on them to strengthen my side's argument. So, starting with the first. Was the assumption of NLG as a terrorist organization justified, and is the Social Media Regulation Act violating the rights of the refugees? Now we need to understand that the degree of war crime and the amount of deaths which were caused, and looking at this type of aggression, we can conclude that NLG is a terrorist organization which has also been confirmed by a chief security intelligence unit. Now, and furthermore, the NLG as an organization has met the criterion of a threat and as well as a terrorist organization. Now, further, we need to understand that the nation of Andaman and the sovereign nation has every right to give it the status of a terrorist organization, which is unquestionable due to the UN Chapter 1, Article 2, Part 7. Now, focusing on the second thing, that is the Social Media Regulation Act. Now, the Social Media Regulation Act violating the rights of the refugees is clearly not justifiable on the basis of that no right is absolute. We need to understand that Andaman has just suffered a terrorist attack, and we have to be careful about a country's national security. Now, we have to focus on the rights of refugees about the formation of an association. Now, if this association would have been formed for a peaceful aim, but what the NLG has done was to plan a terrorist attack, because of which we could not have allowed this group to continue, which further forced us to actually ask for the data, because they had an internal messaging system which the government could not access. Focusing on the second issue, is the Social Media Regulation Act and the official notification number 21 a viable solution? Now we need to understand that the official notification 21, which provided land to build data centers in the eastern part of Andaman, which had cold climate, encouraged business ventures, and is open for supporting any social media organization, provided liberalization laws in accordance with the General Agreement on Trades and Services Part 4, which is an open opportunity but depends on acceptance by the social media companies and is hence unbiased and impartial, which were not agreed by Be Connected. It is handled, yes, now focusing on the third issue, whether the petitioner Be Connected has been unfairly treated by Andaman and has the respondent violated to the WTO. Now we need to understand that there has been no kind of unfair treatment of not only the petitioner Be Connected, but also of any of the foreign industries which are currently operating in Andaman. And secondly, nor has the respondent violated the WTO trade rules. Now we need to understand that the respondent was well within the laws of the World Trade Organization for seeking source code from social media firms in accordance with the Article 14 of the General Agreement on Trades and Services. Moreover, we need to understand that the allocation of land according to climatic conditions did not constitute less favorable treatment under the Article 3, Part 4 of the General Agreement on Tariffs and Trades. Now, focusing on the fourth issue, whether seeking source code from Be Connected in accordance with the Article 14 of the GATS. Now we need to understand that the Andaman's government requests that the foreign social media companies provide the source code does not violate GATS Article 7, as Andaman has not committed to a national treatment plan in the computer industry and the associated services under the GATS. Hence, Andaman is under no obligation to restrict its ability to regulate the business that have been created on its soil. Furthermore, we need to understand the basic fact that asking for data localization and source code is in no way being done to intervene in the user's privacy or the refugees, but to make sure that any kind of activity such as a terrorist attack which took place which can cause harm to our country's national security is not taking place. And furthermore, we can monitor the behavior of the refugees, and the refugee with a good social standing can be granted citizenship of Andaman, which will be of benefit for both the refugees and the country. Now, lastly, we would like to talk about the data localization. Now, we would like to emphasize that Angular has not committed to grant full market access in the relevant services sector and mode of supply, and also the Social Media Regulation Act, which was passed by Angular's Parliament, is protected under the Article 14 under the General Agreement on Trade and Services. And we need to understand that in the prevailing matter, the residents of Ando had uploaded movies on Reconnected of being stalked on the border of Andoin, which caused an all-out assault in Ando, referring to as the China massacre, killing over 1,000 civilians in Ando. It is an addition caused explosive gadgets being detonated in the front of 4 eminent political establishments of Ando. Every member invoking Article 14 has the property to decide its very own stage of safety towards a chance sought to be addressed. Now, furthermore, we would like to emphasize on the Chapter 7, Article 51 of the United Nations Charter, which states that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the UN, until the Security Council has taken measures to maintain the national peace and security. Now we need to understand that the measures taken by a country were in this exercise was an action of self-defense and shall in no way affect the authority of our nation to take this action. Now lastly, we would like to focus on, this is the last issue which you would like to focus on. The policy in the Article 3, Part 1 of the General Agreement on Tariffs and Trade takes into account the measure that should not take life so as to afford protection to domestic production while interpreting the provisions of Article 3, Part 4. Now, as stated in the Chile alcohol case, the purpose or objectives laid down by a member state legislature and government as a whole is to be considered along with its regulatory purposes. Hence, it is submitted that the determination of life products should not infringe upon the regulatory authority, and the Article 3 Part 8 permits Android to accord more favorable treatment to its domestic technology, which we did by letting Let's Talk operate in our country. And now we would like to call the witness.
Please.
The side respondent would like to call Mr. Alan Jolly, a citizen of Android and a consumer of Let's Talk, under Article 62 of the International Court of Justice, and we are very grateful that has flown from Android to the ICJ. I'm starting from the first question. Sir, do you think that the services provided by Let's Talk are overcoming or filling the gap of Be Connected and also providing more benefits than Be Connected?
Surely, so with regard to that, so ma'am, firstly may I answer that question? With regard to that, Let's Talk is a platform that does not provide its users a free service system, meaning that each and every messages present within that propaganda is public, meaning that each and every article, each and every messages sent person to person can be monitored by the government in Let's Talk.
Alright, now moving on to the second question. So don't you think that Let's Talk, by taking data from its users, are creating a safe environment from its citizens by ensuring national security as we are only surveying it?
Yes. In our usage policy, we provide to the users that the messaging will be monitored by the government. So, by creating such a platform, we ensure that such a terrorist attack converted by the energy may not happen in the future. That's all.
Alright, I'm moving on to the third and the last question. So, what would you like to say on the fact that Android was attacked by using a group made on Be Connected, the NGL, which our police and security intelligence unit believes? A simple question: can you, as a citizen of Android, compromise with your private data, which will only be connected to our government?
So, regarding that, the energy attack carried out through Be Connected is simply a matter of incompetence on behalf of the Be Connected workers. Regarding that, I would like to further reaffirm that Let's Talk is coherent and looks up to the government of Andwin, where it shall successfully curb any future assaults such as the energy accident. That's all.
Is having a surveillance state the end of a state? That means you want a state to have a surveillance on every citizen, what they are doing, what they are eating, and does it actually do support that? Because that's what Let's Talk is going to help you do with, and that's what Be Connected refusing to do.
Alright, so ma'am, in the case of Be Connected, they had an internal messaging system, because of which only the Be Connected, but not the government, could not access the and could have not monitored the messages. But in the case of Let's Talk, by taking the data, our main aim is to monitor the data of the refugees and also focus partially on the citizens, so that we are able to see that there is no such thing which is happening which can cause harm to the national security of our country.
Do your country have strict proof that this attack was carried by the refugees? Because there are 8 citizens involved, then how can you be so sure that this attack is followed by refugees only, and you want to surveil refugees only?
Ma'am, when we are saying that we have to survey refugees, we are saying that our main attention has to be on refugees, because if we are not identified them properly, we cannot be so sure that whether they can be a threat to our national security or not. But as far as citizens are concerned, firstly, before that I would like to also state that as stated that the Chief Security Intelligence Unit of Annual has also confirmed that the attack was carried out through the national location. Now, as far as the 8 citizens are concerned, ma'am, we need to understand that, as my co-speaker also stated, that the actions that will be taken on those 8 citizens, which will be under domestic reconciliation law, which will be carried out by our country. But as far as the refugees are concerned, things that do not come under that law, we have to take such actions. I hope that answers the question.
Okay. You didn't give your prayer. What's your prayer? What do you want us to do?
With the due permission of the honorable bench, can the defendant side also cross-question, can also question witness?
No. Sit down. That's not something which is allowed. Yeah, thank you.
And therefore, in light of the measure that issued, reasons given and authorities cited, Annual, the respondent, respectfully request the panel to find that Annual imposition of data localization laws was in line with its schedule of specific commitments. Second, we find that Annual is within the limits of the World Trade Organization law for seeking source code from foreign social media firms in accordance with the Article 14. And third, we find that Annual's treatment is not best favorable to foreign producers, and the Article 3, Part 4, as in consonance with the Article 3, Part 8, Subclause 8, the General Agreements on Tariffs and Trade, all of which is respectfully affirmed and submitted.
It was our pleasure. They are a delight to listen.
A very good afternoon, ladies and gentlemen. After 3 long, tiring days, we come to the end of the first edition of Intra-Mart Moot Court competition, the very first such initiative in the country. Using this forum, I would first like to extend thanks to our judges, who took out time from their professional commitments, since they are working professionals, and graced us with their presence. Gratitude is also due to the logistics and the organizing committee members who have worked hard throughout the past week to make this event possible. I would also like to thank our principal, Mr. Carlyle McFarlane, who not only understood this noble concept, but also encouraged us and became a part of our learning process and provided us with all the college amenities to make this event a reality. Another group of people who should receive a huge round of applause, but rarely do so, are the core team members, working in the background and making sure that everything is carried out smoothly. I would also like to thank Mrs. Sheba Siddiqui, our CCA coordinator, who also assisted us in every step of the way, and her expertise surely was of great help. Finally, gratitude where it is due. This event couldn't have been possible without Mrs. Hani Dhawan, who acted as a guiding light for us throughout the event. Was it a huge success? Maybe not. Did it create the distinction? Probably. However, what we should understand after today is that this is a very noble concept at the school level for both the participants and organizers. And the fact that these many people turned out today already makes it a huge success. I hope that everyone learned something new today, and at last, I would also like to congratulate both the teams who have made it to the finals and also those who did not, as speaking in this event, I believe, in itself is a huge victory, and everyone should give a pat on their backs. Thank you. Now, I would like to call Mrs. Sheba Siddiqui to provide our esteemed judges with a token of gratitude. I would first like to call Dr. Samreen Hussain, who is a law professor at Ram Manohar Lohia National Law University, Lucknow, to receive a token of appreciation.
That's a very small token, ma'am, and which is nothing compared to the amount of time that you all have given. Thank you. Thank you so much. Thank you so much, sir. Thank you. It's our pleasure having you all here. And I mean, I don't know how much we could do for you in La Matnia, and we were not even here to appreciate the time that you've given. But whatever you all have done, La Matnia appreciates that. For the boys the participants. I mean, today I'm seeing just the 2 teams here. But please convey, I was going through those topics that were given over here, and I, being a teacher, was quite zapped with that. So I'm really, I'm amazed and I'm really surprised at the amount of preparation that you boys have done, and to take up such topics at this young age. It's commendable. It's commendable. And very
much beyond our expectations.
Yes. So so congratulations to each one of you.
It's like watching actually law students argue. It was amazing.
For your information, ma'ams and sir, none of the boys have opted for legal studies as a subject.
Oh my God.
That's participants have reached the finals.
Amazing. That's even better.
They definitely have the aptitude.
So we might have future lawyers coming from here now to fight cases for us.
I was just want to say this. Yeah, I am seeing that कि इसमें से कुछ मुझे अपने फ्यूचर दिख रहे हैं. As an advocate हमें बड़ा अच्छा लगता है जब यंग लॉयर्स आते हैं. जब हम लोग आए तो हम लोग को बहुत अप्रिशिएशन मिला और ये बहुत अच्छी चीज़ है जिस हिसाब से आप लोग कर रहे हो चीज़ों को. कुछ चीज़ें हैं जो वाकई देखने की जरूरत है. ठीक है, मूट कोर्ट के लिए मैम बहुत अच्छा बता सकती हैं. हम लोगों ने कई मूट कोर्ट जज किए, मैम लोग को रेगुलरली मूट कोर्ट करा रही हैं. ठीक है, लेकिन हम लोग जो कि रेगुलर प्रैक्टिशनर हैं तो रेगुलर प्रैक्टिसर्स को देखते हैं तो उसमें बहुत सी चीज़ें हैं जो चाहिए हमें. आप लोगों में ये चीज़ आपको फिर से देखना पड़ेगा, थोड़ा सा ये वाला जो साइन होता है ना, इसको थोड़ा सा अवॉइड करना है यार आर्गुमेंट्स के टाइम।
That for debating it works, but not I
For
think as
debating it
lawyers.
works.
Yes.
As
Lawyers.
in the courts,
But
it
not
does
as
not.
lawyers.
ठीक है ना?
The judge
It
has
is not
taken offense.
मिसकंडक्ट ऑफ द कोर्ट। तो इससे हमें बचना है। और थोड़ा सा एक चीज़ और कि फैक्ट पहले, जैसे कि इन लोगों का था कि फैक्ट आपने पहले बोला, फिर आपकी सबसे पहले तो होता है कि आप क्या चीज़ चाह रहे हो, किसके लिए एक ब्रीफ पे आपने बोल करके शुरू किया, आपने अपना फैक्ट बोला, फैक्ट बोल के अपना लॉ रखा, उसके बाद अपनी प्रेयर रखी, ठीक है ना? अगर हम चीज़ें करते जाएं, कुछ चीज़ें जैसे आप जो भी चीज़ बोल रहे हो, आप दोनों ही लोगों के लिए है और भी जो टीम्स थे उनके लिए भी है, जब आप कोई चीज़ अपने आर्गूमेंट्स दे रहे हो तो वेयर यू हैव रिटन इन योर प्लीडिंग्स प्लीज मेंशन टू द कोर्ट, ठीक है ना? तो कोर्ट उसको रेफरेंस तो ले पाए, पता चला हम ढूंढ रहे हैं तब तक आपने वो आर्गूमेंट करके आप नेक्स्ट आर्गूमेंट में पहुंच गए, ये नहीं होना चाहिए।
Noted, sir.
थैंक यू।
Thank you, sir.